Welcome to the European Law Unbound podcast series. I'm Maria Bartel, Professor of Transnational Private Law at the University of Amsterdam and the co-president pro tempore of the European Law Unbound Society. This podcast series was recorded in Prague during our inaugural conference in September 25, and we are thrilled to share it with you. In these episodes, you will discover fascinating law in Europe research from our many participants brought to life with their fresh impressions and insights from the conference itself. We hope you will enjoy these conversations as we look ahead to our second annual conference coming to Lisbon in September 26. Stay connected with us on LinkedIn to keep up with the latest news, updates, and developments from the European Law Unbound Society. We are just getting started and we'd love to have you along for the journey.
Welcome to another episode of our podcast. I'm your host, Jaroslav Denemark from the Department of the European Union Studies here at the Charles University, Faculty of Law. This is yet another special episode from our series that is covering the conference EU Law Unbound. And we have here with us today Joanna Mazur and Anton Naparelski. Is it right?
That's correct.
Naparelski from the University of Warsaw. Thank you for coming and thank you for accepting our invitation.
Thank you.
Thank you for having us.
We should be talking about your research, or you had the presentation today, right?
Yep.
And it was focused on the procedural autonomy and how citizens and civil society can play a stronger role in the enforcement of digital markets legislation. I think that at the beginning, it is very important to say that the digital markets legislation is directly connected with the participation of society or citizens, right? So could you introduce us to your research a bit?
Yeah, so I was the one presenting on the participation of civil society in the enforcement of digital market legislation. So maybe I will just briefly explain what I mean by all these terms. So in the presentation, I focused on three legal acts: on Digital Services Act, on Digital Markets Act, and on the AA Act. But obviously, when we think about digital market legislation, we could be talking about, I guess, more or less like 70 different legal acts right now in the European Union. And many of them have like a separate enforcement system. So they introduce requirements for the member states to designate or to establish new institutions that would deal with the enforcement of these legal acts. But also, these enforcement systems, I see it as something broader than just the enforcement by the main public enforcer designated as responsible for dealing with this particular legal act. Because I also think that all the institutional and procedural solutions that are regulated by this given legal act also include participation, and here we come to the civil society organizations. They can cover, for example, the participation of these societal actors in the enforcement, right? So I argue in my presentation that the way in which we regulate at the European Union level the possibility of civil society organizations to participate in enforcement, it has direct consequences for how we actually protect the empowerment of the society. So, for example, when we want to have stronger protection, we need to encourage the participation in the enforcement, and to encourage participation in the enforcement, we just need to have like proper measures and means to participate. And one of them, as I show on some examples from what has happened so far in digital environment, or with regards to our rights in digital environment, is the representation by civil society organizations. Because when we think about how complex these digital cases are, how you need various types of knowledge on technology, on law, which is quite complex, it's quite difficult for like a lay person who doesn't deal with either technology or law in everyday life to like represent themselves, right, in these cases. And therefore, I believe that it's important to have these civil society organizations who actually try to conduct some like strategic litigation and protect or try to protect our rights for us.
Okay.
So this would be me, and then Anthony was actually, presenting on the procedural autonomy.
Yeah, I think we can say that my research and Joanna's research, they start from the same point.
Mhm.
We see the deficiencies of enforcement models and enforcement structures of EU data law, digital law.
In general.
In general, and I think that the primary example of what we have learned from the past are the deficiencies of GDPR enforcement. We see, great, ambitious, harmonized rules on EU level, and then enforcement left to the member states, which is lacking, to say the least, probably.
The meta cases, for example, that can be enforced only in Ireland,
exactly,
are, I think, good example of this.
exactly. And Joanna's research, comes from this angle of looking at the participation of the civil society. I look at those deficiencies from a different side. I try to understand what role the principle of procedural autonomy plays in establishing those enforcement structures, maybe weakening them as well. And to do this, I have looked quite closely in how the Court of Justice has introduced and has reflected upon the principle of procedural autonomy. The findings are actually quite surprising. All the judgments where procedural autonomy is present, they contain, those chains of self-citation references. The court is referencing previous cases.
Without further context.
That is one thing, that is without further context, but the tricky thing is that if you follow those citations, you end up in one specific judgment, 1976 Reve case, which does not speak about procedural autonomy at all. It speaks about the principle of sincere cooperation. So, it's a completely different optics. We are not talking about a sphere of member states' autonomy, some sort of safe harbor that member states have that can protect them from the intervention of the union. It's the opposite. Member states have a duty to ensure effective enforcement of EU law.
So we don't actually have established case law in this matter?
Well, no, I mean, I wouldn't say this. We do have established case law. It's just
established on one case that is not related to the question.
Well, I wouldn't go that far, that it's, not established case law, but I think it's very interesting development in the case law of the Court of Justice. And, it shows you how repeated citation of the same phrases, the same paragraphs can at some point be incrementally modified. And then, the phrase principle of procedural autonomy was added somewhere along the way.
But, I think that this is actually, if we do not focus on the EU law, this is actually a problem of every jurisdiction, at least in Europe, or at least in the Czech Republic, we know of, that the Supreme Court are just citing what was already cited, and then you go back and then there's just one case that wasn't even really related to the question cited. So
it is, I think it might be, as you say, a more universal problem. I have not looked, into national jurisdictions, but it is an issue of how judges, of how courts build their arguments, how they justify those arguments. And, sometimes when you look inside, there's not much there. Right.
You talk about three pieces of the digital markets legislation, DSA, DMA, AI Act. And what I think is interesting from the point of your research, that I know that the civil society play significant role in DSA. We have the trusted flaggers and this reporting mechanism, as well as in the Artificial Intelligence Act, there is reporting mechanism on quite, I think that if I look at the Digital Markets Act, I see that the role of the civil societies is not as strong in the piece of legislation as it is, in my opinion, in DSA and the Artificial Intelligence Act.
Yeah, definitely.
And what I think is interesting, that the DSA and the Artificial Intelligence Act actually led the member states to enforce those legislations on the member states level.
Mhm.
But if you look at the Digital Markets Act, actually Commission plays a significant role in there. So my question is, how the procedural autonomy look at this differentiation, and how the civil societies can play a role in each of the piece of the legislation?
So you're absolutely right with the DSA. I would agree that not only we have this solution that you mentioned about trusted flaggers, but we also have some provisions on access to data and the scrutiny of systemic risks by civil society organizations. We also have this provision which directly foresees the possibility for the individuals to be represented by
Yes.
nonprofit organizations. So this is like definitely the strongest piece of legislation in terms of the possibilities to participate for civil society. I'm not sure if I would be so optimistic about the Act. I would argue that the civil society organizations are not that present there. And also, for example, we do not have this solution of like being represented by a nonprofit organization there.
Maybe not the organization, but the citizens as such, because of the
like
reporting, the individuals maybe.
We have right to lodge a complaint by American surveillance authorities and so on. So definitely, like there is more there than in the Digital Markets Act, which you mentioned, and this is one of the points that I'm making. That basically, like the division between what we perceive as somehow related to fundamental rights and therefore civil society and citizens should be involved versus what we perceive as related to economy and therefore why should we bother with including civil society organizations is quite arbitrary, because when we think about the obligations imposed by the DSA, it's also about their business model and economic practices, right? So,
but it's maybe more focused on the individuals than DMA.
Yeah, but then
consumer, I don't want to say consumer protection, but you know what I mean.
Yeah, but with DMA, you also have like intersections with the GDPR. You have some end users.
I absolutely agree.
So it's like, I think that to a certain extent it is arbitrary who can be involved under the DMA, and
even though they are closely interconnected, right?
Exactly. So, and I think you're raising very important point about this enforcement by the Commission, because while in general, especially in the context of what we have been saying about lack of enforcement on the states level, for example, in terms of the GDPR on like unequal enforcement. So we have some member states which are very active and we have many which are not active at all. Then the Commission being responsible for the enforcement with regard to these biggest companies, in general, I would say that it's a good solution, right? Because like who has the resources? Like
Commission.
Poland? Not really, or at least we don't want to have them, right?
Hungary?
Yeah, exactly. So basically, in general, I think that this is like very good direction, but I guess that it's the question of, okay, so let's have the Commission as the enforcer, but let's ensure this democratic representation of the society as well. And with the DMA, to be fair, from what I understand, the Commission is very much open for the input from the businesses, from various member states, and they're actually like actively trying to get insights from the business users on what works, what doesn't work, what could be done better, and blah, so on. But the question is like, okay, this is about the business, but what about fundamental rights which are also somehow involved in the issues which are covered by the DMA? And maybe last point before I give back voice to Anthony. So there is also the question of this intersection, right? So when we have this, like so many legal acts, and some of them are enforced by the Commission, some of them are enforced in a hybrid way, a little bit by the Commission, like with the very large online platforms and very large online search engines under the DSA by the Commission, and all the rest by the member states. And some purely by member states, right? Like Data Act, DGA, it's mostly the member states, or also the A Act to a certain extent. And then when you take into consideration these two levels of enforcement and how many various legal acts we have, and also like these differences in how active the enforcers are between the member states, you end up with like such a chaos that what we need is also like very effective tools of aligning these enforcement efforts. Yeah, not to end up losing resources on, you know, so many different proceedings.
Yes, I exactly know what you talk about. When we had a case in Germany where Meta breached GDPR and they wanted to enforce it, but their personal data protection office couldn't do it because the seat of Meta is in Ireland. So they used actually a mechanism where they enforce it through the competition protection of competition office.
Yeah.
And ECG said it's okay, you can do that because it was part of the competition, but it's very hard for the member states, and it's completely arbitrary, as you said it, in my opinion.
Yeah. Maybe I'll make 2 points. One, going back to what you, Joanna, said about the DMA and involvement of the civil society. I mean, I think one important element here that is being used, and I think it brings good results, are those stakeholder compliance workshops that the Commission is organizing. I think there were already 2 or 3 rounds of those workshops. There is, you know, a set day where all of those interested, be that business, be that civil society organizations, you know, they meet in Brussels and they discuss compliance measures proposed by Google, by Apple, by Meta. And they're representatives of those big tech companies, and they have to answer questions from, you know, from the room. It's an interesting way, I think, of involving also civil society, but naturally this has a broader purpose. So I wouldn't be that pessimistic about the DMA. Although I get your point, right? It has a bit different.
It's not on the paper. Then in practice you get it, but when you look at the provisions, it's not there.
Exactly,
so then,
exactly.
maybe let's give them these rights also on paper, right?
But I would just, you know, I would, you know, stay positive, and I really welcome those workshops from the Commission. I think it goes in a good direction. And more generally,
do you think that they are useful, actually, the workshops?
Well, you know,
because in my opinion, you know, it's just, oh, well, we'll do it so it looks good, but
well, you know,
then the lobbying groups come, and
I can't speak for the Commission, naturally, but I think from the perspective of you know, people that have to somehow enforce the DMA, it's helpful to hear the room, to see if the measures proposed would solve the problems or would not solve the problems. Because sometimes, you know, if that's my educated guess, but probably if, you know, the officials of the Commission, they get some proposals from those companies, maybe it's not that easy to assess at the first glance if it's a helpful measure or not. And with those workshops, maybe this allows them to be a bit better informed.
And also just one thing, like, to be fair, when I think about the enforcement in Poland, do we have like any, you know, like workshops conducted by our enforcers that would be like collecting the views of various stakeholders on what do you think about our enforcement of the GDPR? Should we focus on this or that? Or like, so in this sense, like the Commission is doing something that is actually like, yeah, quite unique and quite progressive. So, you know, again, it depends with whom you compare, right?
Yeah.
But anyway, sorry, you were saying.
No, just answering to also your previous question about the broader impact of procedural autonomy. I think, you know, that's a very multifaceted principle, and we can see it being used, for example, by member states in court proceedings trying to defend themselves, you know, for not enforcing EU law well enough. But we can also see that it is being used to secure the judicial independence in a way. And I think that, you know, we can't just look at it from one side. It very much depends on the context of each case.
Can actually this approach of enforcement disadvantage some of the member states who are actually trying to enforce the piece of legislation? You know what I mean? When we look, I don't know, at Romania, if they enforce the DSA or the Artificial Intelligence Act, could actually some of the companies decide, okay, that's where we want to settle because we are free, and nothing will be the official department will not conduct any investigations and enforcement processes with us.
Whoa.
But I think
I don't know.
it's on the side of the companies. I would guess that it's like very complicated choice in which you need to take into account many different factors, right? Because I'm thinking about already mentioned Ireland and like what was first, and it was like rather the companies were there already, and these might have caused this enforcer to be kind of lenient because they were already, somehow dependent on the presence of these companies. So I'm not sure if they would be so willing to change their headquarters just because of the fact that certain country is not that active in terms of...
Maybe taxation is more important.
Might be.
But
Follow the money,
Yeah. I also think, because we can imagine different level of involvement on the member state level, right? So we can talk about the GDPR mechanisms with the lead supervisory authority where things tend to get stuck or slowed down in one particular country. But we can also think about an enforcement of competition law, which, it's organized quite differently. We do have the Commission, but we also have member states who can also enforce the treaty provisions. And I think in this setting, having 1, 2, 3, 4 member states focusing on a specific problem, having that coordinated by the Commission, which also happens from time to time, might be a good thing, right? So I think that the devil lies in the details, how we organize the involvement of the member states. We have different models now. We also have the model introduced by the DMA, which is also different, right? We have the Commission, who is the only authority allowed to issue decisions, but there is room for member states' involvement. They can initiate proceedings, they can investigate in the first stage at least. So I think that the EU legislator is in a way trying out different models, trying to balance on one hand efficiency and effective enforcement, which in many ways could be symbolized by the Commission and the centralized enforcement, but also trying to find room for the member states that would not paralyze the enforcement, but would ensure that different authorities could be involved.
Is it even effective to have different enforcement mechanism for each different legislation piece?
That's a great question, and I have no idea. I mean, this is a problem that I think many people working on those topics have seen and realized already.
Because you mentioned it, each of the legislation being GDPR, AI Act, DSA, DMA, and all of the other legislations, completely different enforcement mechanism.
Exactly. And I think this ties well with the second part of my research, which is on the principle of sincere cooperation. And we've seen, some first hints from the Court of Justice in the Meta Platforms judgment from 23, where a very surprisingly detailed cooperation procedure was outlined by the court. How the competition authorities and the data protection authorities should work hand in hand.
That's the Germany case.
Exactly, the one that you mentioned. So
and actually, we have from last week, we have the guidelines on the alignment between the GDPR and DSA, where also principle of sincere cooperation is mentioned as the main instrument that should be
And I think on one hand, we have this large number, as you said, of different enforcement mechanism structures, different authorities, and it seems that for now, the best way forward is to just follow the principle of sincere cooperation. That's what the court is suggesting to us. But if it works,
then it's still up to not only the member states, but actually on the regulatory bodies of the member states
Yeah, and I think that apart from the very important principle of sincere cooperation in terms of the substance, we also need like very pragmatic solutions. Because I was doing research, I was trying to do research about the enforcement by data protection authorities, which would be somehow useful in regard to AI. So I was looking on, or actually we were looking, because we did it like the three of us, on the cases which concerned Article 22 of the GDPR, Article 15, and whether there were any cases which directly referred to AI. And like how different are the databases of, DPAs all over European Union. Like you have at least one which doesn't have like a search function on the website. You have some which don't publish their decisions at all. You have some that publish decisions in anonymized way. You have some which publish like, everything. And even at this level, when you think about, okay, how to ensure sincere cooperation,
You cannot.
yeah, like
You cannot.
and what surprised, or maybe it's not surprising, but it's rather disappointing, is that we have these tools in terms of technology. We can, of course, it's not like perfect, but we can translate these decisions. So it's not a problem. Like we don't have the language barrier anymore, at least not as difficult as it was 10 years ago or 20 years ago. So it's just the question of like, okay, let's make one database. Let's like, have an agreement that each of the DPAs would like put their decisions in this database, like a common search mechanism to see and be able to compare how actually this works. And of course, it's not happening. And again, going back to the topic of my presentation, we have none other business NGO that basically has the best database of the description and content of the decisions issued by DPAs, right? So this is like, the void on the side of the public enforcers, which is filled by the non-governmental organization. And of course, there are mistakes and, it's like based on the work of volunteers. So like it doesn't cover all the decisions, but in terms of like what is accessible, this is the best we can get.
Yeah, well,
right
that
now.
was actually my follow-up question. What do civil societies actually can do to fill the gap?
Yeah, but like I would like to see them as entities which life is made easier with the legislation, not as organizations which are obliged to, fill the void left by the public enforcers or the EU institutions or bodies. Like, yeah.
So what should they do?
Yeah.
In terms of the enforcement,
No, I think they're like what they have been doing with the strategic litigation and like the cases that we know, like Schrems that you already mentioned, but also the cases about Clearview AI, for example, which they initiated in a couple of different member states to like, check whether actually the practice of scraping photos and, building huge database and training AI to recognize then an individual on the basis of the photo and selling this as a service to law enforcement, whether it's actually legal in the EU and so on and so on. So basically we have a lot of cases that have been initiated by them and are quite significant in terms of our understanding of what our rights under the GDPR actually cover. So yeah, I guess this is like really a great job. And also like, they do like education, right? So this is very important because then like people basically realize what are the rights that they have.
Yes.
And all this often without having like permanent budget and so on and so on. So, and of course being involved in the legislative processes, right? So like, issuing opinions and like proposing like, so quite a lot of tasks. And yeah.
Maybe I would add to this one thing is that as critical as we might be of how public authorities responsible for enforcement are cooperating in some legal domains, I think it's still better than how we could think about judicial cooperation. Because following of what Joanna said and civil society's involvement that's expressed through, for example, private enforcement in courts, does, I think, bear a risk of market fragmentation. If we have it, if we leave it to the hands of national courts that will not necessarily be that concerned of what's the outcome in different countries in similar cases. In theory, for example, in the DMA, there are some provisions that the courts have the ability to ask the Commission, or the Commission can join the proceedings, submit an amicus curiae, and so on. It is less structured than the cooperation mechanisms of the public authorities.
But can you imagine that the courts of another member states are cooperating?
No, I mean,
even though when they cannot cooperate even within the same member state.
This is a complex problem. I mean, I'm not saying I have a solution, but I think it's something that comes with the heightened involvement of the NGOs and the civil societies, because that's the natural path for them to follow. They can do it regardless of what's the attitude of the public authority. They can go straight to the court, but it comes with certain risks.
Perfect. Thank you very much for coming and being our guest.
Thank you for having us. Thank you very much.